Imagine this. You sign up for a mysterious game, enticed by the chance to win millions. The rules are simple. Survive the game. The prize, life-changing money. The risk, your life. Now imagine this isn't the plot of a Netflix series. Oh, it's happening in real life. Could a Squid Game style competition where contestants knowingly risk life and limb for a massive payday actually be legal in the United States? Let's talk about it. Welcome back to Due Process Daily, where we break down the law, the Constitution, and everything in between. Today, we're diving into one of the most bizarre but strangely plausible legal hypotheticals. Could an American version of Squid Game actually happen legally? At first glance, you might think, well, if people agree to it and they sign waivers, then it should be fine, right? After all, this is America, land of the free, home of the waiver. But the law doesn't quite work that way, especially when we're talking about consent, contracts, and bodily harm. Let's start with the basics. In the US, you cannot legally consent to serious bodily harm or death. Even if someone signs a waiver saying, I'm okay with being killed or injured, that agreement would be considered void in virtually every jurisdiction. Why? Because public policy doesn't allow people to waive their right to life or safety in this extreme way. This is a key principle in contract law. Contracts that are deemed to be against public policy, including contracts to engage in criminal activity, are unenforceable. That means a contract saying, I agree to participate in a potentially deadly game for money would not hold up in court. It would be considered void ab initio, invalid from the very beginning. Let's take boxing or MMA as a comparison. These sports involve violence and injury. So why are they legal? Because they're highly regulated. Athletes are medically screened. Referees can stop a fight. There are weight classes, time limits, and safety protocols. Even with consent, these sports operate within carefully controlled rules to avoid excessive harm. Now, imagine trying to legally justify a game where contestants fall from bridges, get shot at, or are subjected to psychological torture. Even if they signed up for it, no regulatory body would license it, and any attempt to operate it underground would quickly lead to criminal charges. Let's be even more specific. Running a Squid Game-style competition in the U.S. would almost certainly lead to criminal liability for the organizers. At a minimum, they'd face charges like reckless endangerment, assault, and potentially even murder or manslaughter if someone died. Participants might also face criminal liability depending on their roles. If a contestant harms another player as part of the game, even with so-called consent, they could be prosecuted. Consent is not a defense to causing serious bodily injury or death in most American jurisdictions. What about states that have looser consent rules or private property laws? Could you run a Squid Game on private land away from the public eye? Again, no. Even on private land, you cannot run activities that result in criminal behavior. Law enforcement isn't going to say, well, it's on private property, so murder is fine. In legal terms, consent is not an absolute shield. In fact, there are famous cases that spell this out. One landmark example is People versus Jovanovich, where the court reaffirmed that consent has its limits, especially when it comes to physical harm. Another case worth mentioning, State versus Shelley, a Washington case where two men engaged in a consensual knife fight. One was charged with assault, and the court held that consent was not a valid defense because the activity was inherently dangerous and socially harmful. So, even if everyone involved is a consenting adult, the law draws a hard line when it comes to activities that risk death or serious injury. You can't just sign a piece of paper and opt out of, legal protections designed to preserve life and public order. Let's not forget about civil liability either. If someone is injured or killed, their family can sue the organizers, and the courts won't care about any waiver or agreement signed beforehand. Insurance companies wouldn't touch this with a 10-foot pole. And even if the game was meant to be simulated, any serious injury could land the organizers in court for negligence, battery, or wrongful death. But let's play devil's advocate. What if a Squid Game style show was structured like a reality competition, minus the life-threatening elements? Let's say it's full of extreme psychological stress, sleep deprivation, starvation, and emotionally manipulative games. But no physical violence. This is where things get murky. Legally speaking, contestants can consent to a wide range of experiences. Reality TV shows like Survivor, Fear Factor, and Naked and Afraid have pushed the limits of what's tolerable. These shows often have contestants endure high levels of stress, discomfort, and public humiliation, and they sign pages of waivers beforehand. But even here, there are boundaries. If a contestant experiences lasting psychological trauma, they might sue. If producers knowingly create unsafe conditions that result in harm, they might be held liable. And if someone dies, even accidentally, the fallout would be swift and brutal, both legally and in the court of public opinion. So if you're thinking about launching America's version of Squid Game, your best bet is to fictionalize it. Use actors, stunt coordinators, and special effects. Make it look real, but make sure it's all pretend. That's the only way you're getting out of this without a one-way ticket to court or prison. Now, some of you might be wondering, what about waivers? Can't a watertight waiver save the day? Here's the thing. Waivers can protect you from some liability. Some, like accidental injuries in a mud run or obstacle course, but they won't save you if your event involves extreme risk, negligence, or intentional harm. You can't waive away murder or gross recklessness. In fact, most states interpret waivers very narrowly. If there's any ambiguity, courts resolve it in favor of the person who got hurt. Judges don't like being told someone asked for it when they end up in the ER, or worse. And then there's the issue of coercion. In Squid Game, many players joined because they were financially desperate. That's not true consent in the eyes of the law. If someone participates in a dangerous activity because they feel they have no other option, a court may find that their consent was not voluntary, especially if they're manipulated or misled. The law is designed to protect life and dignity, even from ourselves. You cannot legally opt into a game where the outcome is death or permanent injury. That's not entertainment. So next time you hear someone say, we should make a real-life Squid Game, just know the only game being played would be in a courtroom. Thanks for watching Due Process Daily. If you found this breakdown interesting, be sure to like, subscribe, and share with someone who needs to hear the legal reality behind viral fantasies. And let us know in the comments, would you ever compete in a high-stakes game if it were legal? Until next time, stay sharp, know your rights, and don't sign up for anything that sounds too deadly to be true.